Like, share, subscribe, leave a comment. Breaking news, Judge Glanville has been removed from the Young Thug case. And this is why. So I want to show you why he was recused, and then we're going to get off into that. You can't make this stuff up. He the chief judge, and he done did everything wrong, everything questionable, has denied Young Thug his constitutional rights to due process. He has done everything wrong, but the secret ex parte meeting really got him. And Brian Steele, Young Thug's attorney, he is a beast. He is a beast. And Weinstein for the other fellow. They not playing. But anyway, let me play this part for you. This is from Bruce Rivers, attorney Bruce Rivers. His channel is CLR Bruce Rivers.
If you remember Kenneth Copeland? Kenneth Copeland was, remember Kenneth Copeland, Lil Woody? He was a very reluctant witness. They asked him his name, or actually asked him how old he was, and he said, "I plead the fifth."
Okay. How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you said you're an adult, what number and years are you?
I plead the fifth.
Can you step outside to your headquarters and jury deliberation?
I mean, and the judge. So what happens when you do that? The prosecutor can offer you immunity from prosecution. Now, one could argue that, well, the prosecutor for the state can't do anything about the feds. Fair enough. But if you don't testify after being granted immunity, the court can then hold you in contempt and hold you in custody until the case is over or until you testify, one of the two. There's 6 here. So you had the prosecutor, you had a witness who was sworn in and now is claiming the fifth. His lawyer and the judge. What you don't have is the defense or testifying cutely like, how old are you? I'm old. You know, like that kind of stuff. So I think that this is bad form. Because later go over, the consequences of not testifying. And the only purpose of that is to pressure that would worse the testimony.
Exactly.
We're going to lock you up.
Exactly.
We're going to lock you up and throw away the key until you testify. So in other words, you have the key to the jail if you testify. We're not going to use it against you, but we're going to hold you in jail. I mean, it's coercive, isn't it? Well, take away your freedom.
It is coercion.
And so,
yes.
Brian Steele and Judge Glanville fucking went at it because Glanville wanted to find out how the hell did you know this information?
And that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd. To me, that never... Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. If all that was an ex parte conversation, how did you find out about any of that? Well, I'm disturbed too. And the reason I'm asking you a question. How did you find out about it? I'm going to ask you the question. Okay. Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made, somewhat accurate based upon what you just said, we're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's the stage. It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's also ex parte for a lot of different other reasons, but I will certainly note that for purposes of record. Well, I'm going forward. What I was told was that Mr. Copeland said, and you haven't answered my question yet. I'm not. How did you answer that question? You're not. No, I will not answer that. Have an ex parte conversation with a party. I mean, a party. Yes. A witness who was sworn in Friday. The court's telling. This is what I was told. If this is not true, not true. The court handed Mr. Copeland. Tell me how you got the information. Listen. Tell me how you got the information. Then we can go ahead and go forward. I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court. It concerns me that you have proprietary information. Why is it information that you should not be having that was ex parte? Why? With a party. Why? State of Georgia. How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years and then supposedly that's this honorable court. Okay. Excuse me, let me rephrase that. This court supposedly said
and it's no doubt that Copeland's lawyer probably told Steele. And so the judge orders Steele to reveal how he knew this. And he's like, I'm not going to tell you. I don't have to tell you. This is privileged information. Well, that pissed off Glanville badly.
And he held Brian Steele in contempt.
He threatens Steele with contempt and jail. And I think he
20 days in jail.
20 days.
Yep. On the weekend.
He's in the middle of a trial. You're going to sentence him to 20 days? Why not just fine him, like $1,000 or something? And it's not his fault that he came across this information at all. And so Steele and a couple of the lawyers filed a motion to recuse Judge Glanville from the case. And guess what? Judge Rachel Krause, the Fulton County Superior Court judge, granted Kendrick's motion to recuse Chief Judge Ural Glanville as granted. Bumpus, who is Copeland's lawyer, filed a motion to quash the order to show cause and to recuse Judge Glanville from that, and that's denied as moot. And Jeffrey Williams' motion to disqualify the judge was granted. And so one of the
Jeffrey
things
Williams is Young Thug.
No doubt that Judge Glanville can and would continue to preside fairly over this matter if the recusal motions were denied. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville. In other words, the appearance of impropriety or the appearance of with Judge Glanville. So they removed Judge Glanville. And what does that mean? Now you're going to start all over. Not necessarily start all over, but you're going to start with a new judge. And, I suppose the judge can just pick up, where the case left off. But it was my impression all along that this case has been mismanaged by this judge. There's no way in hell this jury selection should have taken as long as it did.
Right.
There's no way in hell that some of the shenanigans that have been going on in court should have been going on. Glanville, his ego got in the way. His, I just can't understand how he gets that embroiled in this battle with a lawyer. Who's all he's doing is defending his client the best way he knows how. And I think Steele should be given a pat on the back because
he a beast.
He stood there and he took it on the chin and was ready to go to jail. After he got this order to do 20 days, when he appealed that to the Court of Appeals, and guess what? they stayed that order, so he doesn't have to
Stayed
do
it.
that 20 days. And now Glanville's gone. I think the contempt has been quashed, and so now he's just, back to square one with the new judge. Why would you do that? Why would you do this ex parte after you swear a witness in? The only purpose for that is it should have been done in open court.
Right.
And you want to be as open and transparent with this kind of stuff as possible. So that's our little reaction to, just our breaking news that Judge Glanville has been removed from the YSL trial. Think about this. How long has he been on that trial? Over a year.
Over a year.
Over a year, presiding over jury selection and all this other stuff. And he got a little too comfortable, I think. And he lost sight of what was necessary in that case. So that's
well, he woke up now.
Breaking news that Judge Glanville is no longer in the YSL trial. He's probably playing shuffleboard or doing something else a little more fun than what he was doing. And it's kind of embarrassing for him, but at the same time, he's probably relieved. I would bet.
It's definitely embarrassing.
Follow us on Instagram, follow us on Twitter, sign up for Patreon.
Definitely embarrassing. But I just wanted to play why he got recused. And I'm going to play this, and I'm going to bed. Is this it?
Welcome back to Law and Crime. And this just in for Young Thug racketeering case. We have got a decision by a judge outside of that of Judge Glanville that he is now recused. I have literally just gone over the motion now, and I'm going to go over it with you myself bit by bit. Starting first with the finding of facts. We all know what the facts were. There was an ex parte meeting. One of the parties, that being all of the defense attorneys, were not present for this meeting with Kenneth Copeland. Judge Glanville, along with the prosecution and Kenneth Copeland's attorney, had this in-chambers meeting talking about him pleading the fifth for about 4 pages. So about four or so pages, just the facts as we remember them. This meeting happened. Glanville went back and forth deciding, is this person going to testify? You cannot plead the fifth. The prosecution, as we saw the transcripts that were later released, kept pressing. You've got immunity. You cannot be prosecuted for this in any way, shape, or form, and that means you have to testify. Ultimately, that meeting was not expressed in detail to defense until Brian Steele, the defense attorney for Young Thug, raised this issue. Following that, multiple defense attorneys filed motions for recusal. Now, moving on from the facts, going to the law. The legal framework for what a recusal requires.
This is from Law and Crime.
There are 3 criteria that needs to happen. Those being, the motion needs to be timely, needs to be supported by an affidavit, and the facts alleged need to show that a recusal might be warranted. Now, to the first 2 parts, Judge Glanville himself said that this is timely. When the defense found an issue, they brought it up. The second part, he said that there was an affidavit that was filed. Good. But the reason why Judge Glanville himself said that he's denying the recusal is because he argued that the facts alleged did not warrant a recusal, that they did not meet that threshold. However, he ultimately passed this case on to another judge, and this is the judge's analysis and discussion. It's just a quick, I wouldn't even call it 2 pages. I'd call it a page and a half, if that. And the judge does start off by saying, as previously announced on the record, this motion was timely, supported by an affidavit. Already got that. But moving on to the next part, the court kind of pauses and says, you know what, it's worth noting, that I'm just quoting here, that this court agrees generally with Judge Glanville's assessment of the proprietary of the meeting, that ex parte meeting, saying, okay, that's okay to happen. While the meeting could have and perhaps should have taken place in open court, kind of giving that option there, nothing about the fact of this meeting or substance discussed was inherently improper. However, and this is the big however, in his order denying defendant Kendrick's motion and in the process of making a record on July 1st, Judge Glanville added facts, provided context, questioned the veracity of the allegations, and otherwise explained his decision and actions, and argued why those actions were proper. Just going to keep going through here. While, and I'm quoting here, may be appropriate for judges to disclose information relevant to his potential recusal. Such a disclosure must be made in a way that is objective, dispassionate, and non-argumentative as possible, said that the judge is not reasonably perceived as a hostile witness or advocate. As we saw in Judge Glanville's recitation of why he was not recusing himself, he was, let's just say he was definitely a little hostile.
He was.
In presenting this record as to the recusal issues and in ruling on Kendrick's motions, Judge Glanville, quote, evaluated and accepted mandating his recusal. What that basically means in English, he played both witness and jury in deciding the veracity and the truthfulness of his own allegations. A judge cannot do that. That's what the Honorable Judge Rachel Krause, who was given this case to decide the recusal, ultimately decides. They continue by saying that this court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied, but, and going on to quote here, the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. And this is the decision. Based on the foregoing, this court hereby orders the following. 1, Defendant DeMonte Kendrick's motion for recusal, Chief Judge Yerville, is granted. 2, Caleb Bumpus' motion to quash the show cause order or for the recusal of Judge Glanville is denied as moot meaning that it's no longer an issue, and that the defendant Jeffrey Williams' motion to disqualify or recuse Judge Glanville for all further dealings in the above referenced case as amended and supplemented is granted. The court clerk shall reassign this case using the court's case assignment procedures. This is 2024. That is today. What that basically means is Judge Glanville is no longer the judge in the Young Thug RICO case for any of the defendants. It will go back to the court clerks to reassign this case. This is the breaking news coming out of the Young Thug case in Georgia. All right.
He did it to himself. I was shocked when I watched, and he gave Brian Steele 20 days to do on the week. At first, he was putting him in jail that same day, and then Young Thug was sitting there without an attorney, so he let him stay that day and said that he changed it to you do 20 days. Weekends, and so Brian Steele, he a beast. He said, well, I like to share a cell with my client so we can continue working on the case. I just threw my hand. I was like, go ahead, Brian Steele. Whatever that man chart, he is a beast. And that's the update. Like, share, subscribe, leave a comment. Uh-oh.